right to remain silent. Anything you say may be used against you in a court of law. You have the right to talk to a lawyer now and have him with you when questioned. If you cannot afford a lawyer, one will be provided for you. If you do not have a lawyer, you can remain silent till you have talked with one. If you choose to say anything, you can stop at any time that you wish. You understand them thoroughly.
Miranda rights are a staple of police dramas. We've heard the words, "You have the right to remain silent," hundreds of times. But how many of us really understand what Miranda rights mean or why they are read to someone who is accused of a crime? Many of our ideas about the judicial system are shaped by what we read in the paper and see on television or at the movies. Although the law and legal system touch upon almost everything we do, these sources don't always give us an accurate picture of how the system really works or its constitutional basis. I'm Lester Holtz. In this program, we will follow a case through the criminal courts to get a behind-the-scenes look at our criminal justice system in action. The U.S. Constitution guarantees all Americans basic rights, including freedom of speech and religion, freedom from self-incrimination, and freedom from unreasonable search and seizures. Our nation's founders feared that a tyrannical government could strip the people of their rights and made the courts responsible for ensuring that the government doesn't act against the people. Due process means that no matter what you are accused of, the government can't punish you without first proving its charges in an open court of law. Due process rights provide you with a guarantee of a fair trial. You are guaranteed the right to have an attorney appointed if you cannot afford one, the right to be free from unlawful searches, the right to be considered innocent until you're proven guilty, the right to confront and cross-examine your accusers, and in most cases, the right to a jury trial. Every criminal case which comes before an American court is governed by these principles. Some critics argue that upholding these rights can bog down our judicial system. However, our nation's founders felt that ensuring due process was essential to the preservation of freedom. Criminal laws regulate the conduct of individuals and help to maintain order in society. Although specific laws vary from state to state, a crime is always composed of two elements: a criminal act and the intent to commit a crime. Both elements must be present for a crime to be committed. We have staged this fictional crime to illustrate how constitutional principles shape our criminal justice system. We'll follow our suspect, Sally Clark, from her arrest through her trial. Before Sally Clark's case is brought to trial, a number of preliminary steps take place, beginning with the filing of a criminal complaint. The complaint officially informs the accused of the charges against her. It lists the date and location of the crime, the elements of the crime as defined by law, and briefly describes how the defendant is alleged to have committed the crime. Before formal charges can be brought against a defendant, probable cause must be established. It is important to remember that probable cause only means that based on the facts available, the charge against the defendant seems reasonable. Being charged with a crime is a serious event, so the law requires a probable cause finding before pursuing a case in court.
Well, probable cause is basically a reasonable suspicion that a crime or criminal activity has taken place. What that means in English is essentially a police officer can't just pull somebody off the street, throw them against the wall, throw them in jail just because they look funny. On the other hand, the police officer doesn't necessarily have to see a crime taking place, be absolutely convinced beyond a shadow of a doubt that the person he's arresting has done the crime. It's something in between.
This is the case of Middleburg versus Clark. Mr. Scott, have you received a copy of the indictment?
Yes, Your Honor, I have.
And on behalf of your client, do you waive reading of the indictment?
Yes, I do.
Ms. Clark, how do you plead?
Not guilty.
At the initial hearing or arraignment, the judge informs Sally Clark of the charges against her. He instructs her of her rights, especially the right to an attorney, and asks for a plea. If the accused enters a plea of guilty, sentencing will be the next step. If the plea is not guilty, the judge will schedule trial and set bail.
Ms. Clark, I'm going to set a trial date of January the 6th. There will be a $4,500 bond. It will be a recognizance bond.
Very fine. Thank you very much, Your Honor.
You're welcome.
Our defendant, Sally Clark, has pleaded not guilty, so her case has been scheduled for trial. Before the trial even begins, the attorneys can make motions to the court on specific issues in the case. Motions protect the court record and the rights of both the defendant and the state. In Sally Clark's case, her attorney can make a motion to exclude evidence from the trial if he feels the evidence was illegally obtained. The judge presiding over the trial rules on the motions.
A pretrial motion is a motion made by a lawyer before the start of a trial requesting the judge to decide that issue. An example of a pretrial motion is a motion to suppress evidence. That's where the defense attorney believes the prosecution will introduce illegally obtained evidence and is requesting that the judge exclude that evidence from the trial. Howard, look, you know you're not going to get a felony conviction for breaking and entering with intent to burglarize in this case. She's a college student. She lives with her grandmother. She has no prior convictions. Your evidence is weak. Why don't we give her a break in this case?
There's no way I can cut a deal like that. I'm not going to cut her loose, so we got the next door neighbor sees her in the backyard.
To avoid taking the case to trial, the attorneys may agree to discuss a plea bargain. A plea bargain works like this. The defendant agrees to plead guilty in exchange for a negotiated sentence. Sometimes the parties agree to an appropriate alternate sentence, such as drug or alcohol treatment or community service. Some critics view plea bargaining as a way for criminals to get off lightly. However, others see it as a way to fairly and efficiently reach agreement on an appropriate sentence and to avoid long and expensive trials. In any event, the plea bargain must be presented to the judge, who may approve, disapprove, or modify it. Sally Clark has turned down the opportunity to plea bargain and has chosen to have her case resolved at trial.
We're here today to try a criminal case. The defendant in this case is Miss Sally Clark. She is charged with breaking and entering. It's alleged that the crime occurred on October 20th, 1990 at approximately 6:30 p.m. Ladies and gentlemen, have any of you heard or read anything about this case? Do any of you know the defendant or any of the parties that have been mentioned in this case? Mr. Scott, do you have any questions at this time?
Yes, I do, Your Honor.
You may proceed.
Thank you very much. Good morning, ladies and gentlemen of the jury. My name is Robert Scott, and I am the attorney for the defendant in this case, Sally Clark. At this point, I would like to ask you just a few questions about some general matters. First of all, have any of you ever been the victim of a burglary of your residence?
I was.
Prospective jurors are questioned to minimize bias on the jury in a process called voir dire. When a prospective juror appears to have an interest in the outcome of the case or is biased in some way, an attorney can request a challenge for cause to exclude the individual from the jury. An attorney may make a preemptory challenge simply because his or her gut instinct suggests that a prospective juror may be unsympathetic. There is no limit to the number of jurors who can be challenged for cause, but preemptory challenges are strictly limited.
Your Honor, if it please the court, I would like to exclude Mrs. Stone from any further deliberations on this case for cause.
Lanolin Plus presents They Stand Accused. 5 years and 7 months ago, Johnny Chalmers was born.
Actual courtroom trials are rarely as dramatic as they seem on television. However, they have serious real-life consequences for those involved. In addition to the judge who presides over the trial and rules on the law as it relates to a particular case, courtroom personnel include the bailiff, who oversees the jury and maintains order in the courtroom, the clerk of the court, who swears in witnesses and files all documents and evidence entered at the trial, and the court stenographer, who keeps a complete record of the trial proceedings.
Today we will hear the case of Middleburg versus Sally Clark. My name is Howard Burke, and I'm the prosecutor in this case. As a prosecutor, I represent all of the people of Middleburg, and it's my duty to present evidence to you that will show beyond a reasonable doubt that Ms. Clark is guilty of breaking and entering.
Opening statements are summaries of what each side intends to prove. They are not evidence. In the opening statements, the prosecuting attorney explains how the state plans to prove Sally Clark's guilt beyond a reasonable doubt.
There's been no misunderstanding here. Ms. Clark is not a victim. She's a criminal. Mrs. Thurber is the victim. Mrs. Thurber is afraid to be in her home alone at night. Mrs. Thurber and her neighbors have installed extra locks on the windows and doors of their home. I believe most attorneys, during an opening statement, are trying to introduce their basic theory of the case to the jury. It's their first opportunity to address the jury, usually without interruption from the other side or the judge, as long as they follow the rules. And it's basically an introduction to your case. Much like a grammar or high school or junior high school or college paper, it's the introduction of your story. The evidence and testimony is the body of your story, and the closing statement is the conclusion.
The opening statement for the defense attorney will seek to establish that there is a reasonable doubt that the crime occurred, as prosecution alleges.
Before they've heard the evidence, you can, in a sense, train them to look at least potentially look at things your way, and especially since there's at least two sides to every story, that's very important. Could you please state and spell your name for the record?
Madge Sear, M-A-D-G-E-S-E-E-R.
And where do you live, Ms. Sear?
1110 Maple Drive.
And where exactly is 1110 Maple Drive in relation to the crime scene?
Right next door. I'm Mrs. Thurber's neighbor.
And can you see Mrs. Thurber's backyard and deck from your kitchen window?
Objection, Your Honor. Counsel is leading the witness.
Sustained. Mr. Burke, would you please rephrase your question?
Do you have a kitchen in your home, ma'am?
Yes.
And do you have a window in that kitchen?
Yes.
Exactly what can you see from your kitchen window?
The attorney prosecuting the case for the state has the burden of proving to the jury that Sally Clark is guilty beyond a reasonable doubt. The defendant doesn't have to introduce any evidence, although she can choose to do so. The prosecution can't make the defendant take the witness stand. The judge will instruct the jury that they may not hold it against the defendant if she chooses not to testify on her own behalf.
Ms. Sear, you've testified that you saw on October 20th at 6:30 p.m. the defendant in the backyard of the Thurber house. Is that correct?
Yes.
Now, Ms. Sear, it was 6:30 in the evening in October. It's dark outside. You couldn't possibly have seen the defendant from 25 feet away, could you?
Objection, Your Honor. May we approach?
Approach the bench, please. Mr. Scott, I'm going to ask you to refrain from asking argumentative questions.
Sidebar consultations are often used to resolve legal matters that may be prejudicial if aired before the jury. In order to keep these conversations confidential, the attorneys approach the bench to talk with the judge.
Ladies and gentlemen of the jury, you have heard the prosecution's case against my client, Sally Clark. At this point in their case, the prosecution must have proven to your satisfaction that Sally Clark is guilty beyond a reasonable doubt of the crime of burglary. If the prosecution has failed to prove her guilt beyond a reasonable doubt, then you must acquit her. And in order to convict, the prosecution has brought forward a witness.
In closing statements, the prosecution and defense review the evidence presented in Sally Clark's trial. Each side asserts that the evidence supports its case. Closing statements are arguments, not evidence.
It would seem very difficult for the average person to have seen anybody, my client or any other person, and be able to identify them clearly. The standard of proof, called beyond a reasonable doubt, is used in a criminal case only. And that standard of proof requires the prosecution to prove to a moral certainty that there is no other alternative explanation for the conduct of the defendant other than guilt. So it's difficult to prove, and it is something that we rely on very heavily in our criminal justice system.
Ladies and gentlemen of the jury, you've heard the evidence in the case, and now you've heard the arguments of the attorneys. At this time, it's my duty to instruct you as to the law. You must follow all the instructions I give you and not single out any particular instruction.
The judge advises the jury on the law which they must consider in their deliberations.
You must listen to your fellow jurors, but you should not abandon your own views. Each of you must decide the case yourself, but only after impartial consideration of those views of your fellow jurors.
The jury's verdict is always read in open court. Following the verdict, sentencing and other post-trial proceedings will take place.
The appeals process is designed to correct errors that are made at the trial level. In our society, we are so interested in protecting the rights of everybody that we give people a second shot at their case if, in fact, they believe errors were made at the trial level. The prosecutor, the state, may never appeal the acquittal in a criminal case.
Basically, our rights and our civil liberties guaranteed by our Constitution are there for a very good reason. Our basic principles are that we would much rather have a couple of guilty people go free rather than having any innocent ones go to jail.
The jury system is an essential part of this process because it allows individual people in the community, everyday people, neighbors, to come forward and serve on a jury to decide the guilt or innocence of a defendant.
The legal process can sometimes seem complex and technical. Concepts such as beyond a reasonable doubt or probable cause may mean very little to the average person. However, these distinctions can mean everything to an accused individual. Even if you are never involved in a trial, understanding how the criminal justice system operates can make you a more informed citizen. In real life, our legal concerns are not resolved as easily as they are on television. The more you know, the better you'll be able to make the decisions that count.